this matter, I have already I have purchased the property through e-auction by the bank. And in the meantime, the bank has received the entire amount, my lord. Then after that, the bank is now transferring the property. And it is a matter of 2024, my lord.
After 2 weeks.
Beg your pardon, my lords.
And another matter, my lord, is the specific direct
tomorrow again.
But one day my friends were better. Yesterday he was supposed to be.
I'll take that. I'll propose it.
Yes, your lordship.
Yes, admission.
Your lordship had practically directed a writ petition matter to be listed yesterday. It was 1st of September, but somehow it has missed a late. Grateful, my lords.
Resolution lecture notice came well. This got all by lordship not there.
Yeah.
My lord, I don't know what 32, 33. I'm allowed to withdraw the matter.
You want to withdraw? Wait.
Matter is infructuous.
They have become infructuous. 32, 33?
32, 33. I don't know what 32, 33.
32, 33. Learned counsel for the petitioner seeks leave of the court to withdraw the petitions as having become infructuous. First, he has also filed a memo to the said effect, which reads as that next time, in the above circumstances, petition is disposed of accordingly.
I don't know 58.
58.
Well, that relates to that class 6 student, admission of class 6 student, others of Vidyalaya. Can it be, yesterday also it was there at the last case, can it be taken at 2 o'clock subject to my lord? It will one mention it.
But to mention, my lord, here of the 2024 matter, will also for the instruction. Instruction, it has not been listed. This matter is 2024 matter.
Well, item number 34, I am the opposite party on behalf of Mr. M.K. Mishra, my lord.
Item number
34, madam. There are two connected matters.
34.
Yes, madam.
Whether it is posted on the memo?
No, madam.
No, on its own it has come.
Yes, madam.
34. Call up.
My lord, 4 week time for filing counter.
Only 2 weeks. 2 weeks for filing objections to this counter. If failing which, right to file one stands for PT. Yes.
Pardon your lordships. I may be pardon your lordship.
In this case, I received the counter, my lord. Only 2 weeks time you granted to file agenda.
38. But other side, you have informed the other
Only
side.
statement.
Okay.
Pardon your lordships. I am on VC, your lordship. I humbly pray for an adjournment.
And another matter is 42.
42.
Man. In this case, counter has not been filed.
42. 24 method.
Man.
If they are not take advantage of that. Or you want time?
No.
I am for opposite party on this, your lordship. Item 40.
Yes, sister.
I beg pardon, mention, my lord. My lord, what
You've
matter?
been running now.
Yeah, my lord.
What
My
did-
lord, one matter I had mentioned before your lordship under the PCP Entity Act, my lord. Your lordship had allowed the memo and the matter was supposed to be listed today. It shows.
It was supposed to be posted to.
Yes, it is written, my lord, 2nd of September.
You sit down. Sit down.
Pardon your lordships.
See that.
My lord, can it be taken up tomorrow, my lord?
The day after we did.
On 4th.
On 4th.
Yeah, on day after today's.
4th.
Yes.
Okay.
Pardon your
Please,
lordships. Your lordships, I may be pardoned. I am on VC, your lordship.
Fresh admission.
Yes.
It will come automatic. But anyway, things when you want to find. Yes.
Pardon your lordships. I am on VC, your lordships. I pray for an adjournment of item number 40, your lordship. We have received your lordship. I am for OPEPA, your lordship. OP number 2, your lordship. I think. Your lordship, we have received the rejoinder. We need some time to prepare, your lordship, for hearing.
But it is moved matter, na? See, what sir? Serial number 40.
Yes, sir.
Is it a moved matter? Has it come before the court because of memo?
Yes, sir. It mentioned.
Yeah, the party.
Your lordship, I have taken consent of the counsel of the petitioner, your lordship. Yesterday only I have taken consent. It might be. Yes, your lordship.
Consent says that I have not given consent. We will take up the matter in your absence. Call after 2 weeks at the request of.
Your Lordship, similarly, another matter is the item 42, Your Lordship. Today we will be filing the counter, Your Lordship, within the course of the day.
42, is it mentioned matter?
Today we'll file the counter, Your Lordship.
You also sought for 10? 2 weeks. Support concerns.
Oblige, Your Lordship.
Item number 1?
Particular my lord, item 7 and 8, my lord.
7, 8?
My lord.
You want time in that?
My lord.
Well, there are matters for admission, we can issue.
Actually, Mr. Chand is out of station, my lord, right now.
Is it? After 2 weeks?
My lord.
2 weeks. Get the request on.
My lord,
Item number 1?
my lord, my lord, I'm in this.
There portion, page 12.
Well,
Well. Directing the opposite party to consider the appointment as level 5 assistant teacher with effect from 1/7/2014 to counting from 6 years from service, date of absorption of Ganashikak, my lord. But 2 years I am
with the identical matters we have already sent.
That is WPC number.
Issue notice, learned DG requested to accept notice for all students. All OPs.
Yes.
Oh,
All OPs, all this matter along with WP number. Yeah, okay.
that matter is 3rd week of October, my lord.
Yes. You give copy to your brother. Copy of the petition
Okay.
along with document. Yes.
Item number 2. It is this matter, my lord, that premature release of life convict matter, my lord. Last
But it comes before me only.
That is the
said that-
lordship. That is the other matters which was not listed before any other bench that will come to your lordship's court.
But it comes before us on this. Is it?
And my lord,
Where is
already,
that, one matter I decided now?
Yes,
Which
my-
you had appeared. Where is that order?
my lord. My lord. This is the order. Another court also disposed of another matter. I have also stated for your lordships. And also in the meantime, some petitioners filed WPC
Objections.
Let me.
again.
Yeah. Can we call it this next week? Next week. Issue notice. The AG is requested to accept notice for the respondents. But several such orders we have made actually. Anyway, you just look into.
And also our Honorable High Court, Chief Justice Court,
You have given copy.
yes. Another,
Speak on board.
item 3.
Block pension matter. You lordship batch of matter posted to 3rd week. Come along with me.
Yeah, issue notice that the AGA is requested to notice for respondents. Call this matter along with WP number
Along with 20,000 of 20,017 of 2025.
20,070.
17, madam. I am giving it, madam. I am giving in writing.
Yeah. Give that, give one small sheet.
Item 4.
Petitioner is working as a botany lecturer.
Use up.
My lord. Petitioner is working as a botany lecturer at Daspala College. His salary was stopped by the principal from the April month.
Not paid.
Not paid. So I have made a representation to the director, my lord. Annexure 4 series.
If considered, you will be happy.
Yes, ma'am.
But the short grievance of the petitioner is as to non-consideration of his representations dated.
Dated
Exact.
16/7/2025.
16/7/2025, a copy whereof awails a connector was, wherein he has sought for releasing of the salary that allegedly has accrued during the period between April
Today, ma'am. Till today.
April and August 2025. From accrued with effect from April 2025. First, next paragraph. You will consider that representation. Who should consider?
Opposite party number 2, man.
Learned AG appearing respondents, standing tall at the bar and fairly submits that he would instruct OP number 4 to look to OP number 2 to look into the grievance of the petitioner as has been aired in the subject writ petition, and also the representation in a time-bound way and in accordance with law. Provided that all contentions are kept open. With this proposal, counsel for the petitioner is agreeable. Next paragraph. In view of the above, petition is disposed of, fixing a period of 2 weeks for taking the decision on the subject representation, and also to inform the result of such consideration to the petitioner. First off, it is open to the answering OP to solicit any information from the petitioner or from any other quarters as may be required for due consideration of the subject representation. However, in that case, delay shall not be proved. Yes, no cause.
Item 5.
5.
Item 5.
Go to the prayer. None appears.
State is not a party. Odisha Milk Federation.
Milk Federation.
Yes.
Whether Milk Federation is held under Article 12.
This Honorable Court has been held.
Is it? Issue emergent notice. Yeah. Yes.
Item 6.
Item 6, may I please, Your Lordship?
Yes.
Your Lordship, the petitioner is a demonstrator and he's praying for the grant of RACP benefit, Your Lordship.
Similar matter we disposed of na other day. Which is
Your Lordship, issued notice.
Why we should notice. Yes. Issue emergent notice. Learned AG on request accepts notice for the OPs. All OPs.
Yes, Your Lordship.
No.
Call along with WP number.
Except
22638.
Notice 25.
except 5.
Okay. WP number.
22638 of 2025.
Call along.
Item 9.
Yes, Your Lordship.
May I please, my lord? This is part of the batch of the matters your lordship is hearing regarding financial benefit under
It's already
Well.
sent notice issue.
similar.
Issue notice, learned AG accept notice. For OP, all OPs.
Well,
All OPs. Call along with WPs. Yes.
correct.
Item 10.
May I please, madam? The petitioner, my lord, as a regular primary school teacher, retired on 31/3/2024.
31/3/24.
My lord. His representation is pending at Annexure 6. Is claiming pension and pensioner benefit, my lord.
They are not giving
No, my lord. No, my lord.
benefit.
No, man.
Why, brother? Why are you doing like this even after retirement? How they should survive? Which is your
Annexure
representation?
6. Annexure 6, page 20. Before the opposite party number 2, the Director of Elementary Education.
The short grievance of the petitioner is as to non-settlement of the terminal benefits, he having retired from service on
31/3/2024.
31/3/2024, having attained the age of superannuation. First, learned counsel for the petitioner submits that in the light of apex court decision in Padmanabhan Nair versus so and so, 83 perhaps Supreme Court,
He's claiming pension.
Terminal benefits, all terminal benefits.
He's claiming pension under the old rule.
You consider representation.
In fact, he was regularized to 2013.
You told him in your reply.
Yes.
What you written? Submits that. In the light of apex court decision in DS Nakara versus Union of India, the pension and terminal benefits payable to a retiree are not a bounty, and therefore the state is under a constitutional obligation to settle the same in accordance with law and at the earliest. First one. Next paragraph. Learned EGA having opposed the petition for some time on the ground that petitioner may not be entitled to pension under the amended, under the old rules,
1992 rule.
1992 rules regulating the fixation and the grant of pension and terminal benefits, now fairly agrees to instruct his client, that is OP number 2, to look into the grievance of the petitioner as has been aired in his representation dated 18/4/2024, a copy whereof avails at Annexure 6. First one. This is appreciable. Next paragraph. In the above circumstances, 8 weeks says open to solicit information, etc. Okay. Yes.
Item 11.
Time limit may be fixed.
Yeah, 8 weeks. Yes, Mr. Milo.
The second journey, my lord, my service was terminated. I have succeeded in the appeal, and that order was challenged by the management before my lord, and it was upheld. That order confirmed, and I am to be joined back in service. However, this honorable court has directed to proceed with me and complete the process within the DP within a time limit, my lord. Till then, the time limit is over. Still, my lord, instead of proceeding with the proceeding, they placed me under suspension again, and I am now without anything, my lord.
When with effect from 27 February, my lord, what are the charges?
Charges, my lord, those charges also now it's not existing against me. Yes, that is they say that is a misappropriation money. They have reported an FIR to the police. Now the police case has also been dropped because they didn't find any clue. And the case in the High Court is also dropped. That is also I've stated, my lord. So that is not really politically vindictive because the ex-MP was the president of that law college. He has placed on suspension because it is mandate. Now they have also over, their term has over in 9/4/2025. So ADM of the district is now directed by the Regional Director of Education to be there in charge of the governing body. He is also not taking any action.
Take notice. Well, AGA issue notice. AGA is requested to accept notice for the OP numbers.
My lord, because now ADM is the governing body. ADM is under them.
But let the formal notice go to R4, OP number 4.
Yes, but that officer is the government officer.
Okay. Emergent notice to OP number. Okay. Post immediately after service. Yeah.
For an early date, for an early
No,
date.
after service you can.
Yes.
Item 12.
Item 12, my lord. May it please your lordship.
Yes.
My lords, this is a writ application challenging the blacklisting of the directors of a company, my lords. They have filed this in a personal capacity before your lordships. They are the directors of a public limited company, my lords. Now, this company was engaged in business with Rourkela Steel Plant, and my lords, for the last 60 years. And my lords, what happens? Because there was a defect in a bank guarantee, it was not actually a correct bank guarantee. The company itself offers to replace the bank guarantee immediately. The Rourkela Steel Plant doesn't catch hold of the company. The company itself volunteers to give back the bank.
Personal grievance. I'm sorry.
My lord,
Company is the aggrieved party.
Company is the aggrieved party. And that is a subject matter of a rate application before your lordship.
From RSP side.
No. The caveat is for the company, Bhilai Engineering Corporation Limited. We are the directors, man.
What is
My grievance is, the directors have been personally blacklisted.
Where is that?
Oh, Annexure 1, page 31. Lordship kindly says page 31, MS Bhilai Engineering Corporation Limited, that is the company, including its proprietor, partners, directors, without a show cause to us. Sorry.
Sentence I should be convinced.
First sentence, one. MS Bhilai Engineering Corporation Limited, Bhilai, including its proprietor, partners, directors, is hereby banned from having business dealings with all plants, units of Steel Authority of India Limited, SAIL, including its subsidiaries for a period of 3 years till 28, considering
the other connected matter is posted.
I think
You take notice and you can file your objections.
We can, my lords. The only thing is the other matter is posted to tomorrow. We are taking steps to file a counter there. And most importantly, in the certificate of this writ petition, they have not disclosed that the company has filed an independent writ.
Why
So
should
that
we?
non-disclosure also has to be dealt with.
Is it a non-disclosure, my lords?
My lords.
You take up that contention. There are some judgments to that effect also in A. Ramayya's company law. He has mentioned a few, just refer to them. Okay.
Salman versus Salman is very clear, my lords. Company is a separate legal entity.
Not Solomon. Solomon.
Sorry, I'm sorry, sir. Yes,
Issue notice.
and we have annexed that order also, your lords.
Issue notice.
My associate accepts. Mr. J.R. Dev.
Sri so is on caveat for
Sole opposite party, Steel Authority of India.
for the respondent. First time. We'll call this matter tomorrow along with that and we'll give time in that so that in both the matters you can file your first. The counsel for the caveat, plus the counsel appearing for the caveator submits that the subject company has filed WPC number
WPC number 18,264 of
254 of 2025, wherein notice has been already issued, and therefore this petition be tagged to that petition. First, the net counsel appearing for the petitioners is agreeable with the proposition. First, call this matter along with WP number. It will come again tomorrow. So that will give some time. Together they will come.
May I pray, my lords, that an interim order may be passed, staying the suspension, staying the blacklisting of
Interim order granted in that manner.
No, it's here in the show cause notice itself. No, I understand, my lords. But what my problem is,
main matter itself, we have not given the interim order.
this has no connection with the main order. May I just explain for a minute, my lord?
Let us see, may not be, but I am not knowing. And instead of suffering rejection of your interim prayer, we can call this matter on with the main matter, another matter. In both the matters, we
because, my lords, in the main we have never been given a show cause.
That's what.
We have never been heard in the matter, and I've been we have been blacklisted. My lord,
he is on caveat.
No. His caveat is against the company, my lord.
Let us see.
Tomorrow, I will press my prayer.
Now that I am appearing, let them serve a copy.
I will serve a copy. No,
serve copy.
Yes, certainly, man. That we will do.
This, my lords, involves fake bank guarantees.
Let us.
Something very serious.
No, but
let us see.
Then, my lords, how can the directors be held responsible in their personal capacity without issuance of a show cause to the directors?
No. In Fox and King latest decision, the Apex Court has referred to two decisions, one of America, another of England, and abroad, saying that where the directors of a company play mischief, fraud, or fabrication, the court can lift the veil.
Corporate
therefore,
certainly, my lords, but then with a show cause to me.
That's my lord, the 5 judge bench now holding the. We are grateful.
Yeah.
Oblige. Oblige.
Petition is a retired senior assistant of Withdrawal University. While this writ petition challenges the inaction of the opposite party number 1 and 2, as they have not sanctioned this pension and pensionary benefit in favor of the petitioner, whereas the similar situated persons are getting pension as per Orissa Civil Service Pension Rule 1990.
Representation is 26,625.
Yes, madam.
If direction is given to consider that, you will be happy.
Taking into account,
Notice go.
yes, taking into account Annexure 6 and Annexure 5 and 4.
Let us see. Let the notice go in. Any panel counsel for the
Yes,
petition?
yes.
Who? Issue number 10 notice. Returnable with the
Mr. T.N. Patnaik, Tarananda Patnaik also.
Shri Taranand, the panel counsel Shri Tarananda Patnaik is requested to accept notice for all respondents.
No, opposite panel 1 and 2.
1 and 2. Emergency notice 2, 3 and 4. Post after, immediately after service. Okay.
May I clearly come take instruction? My learned senior can take instruction as matter relating to pension.
Yeah.
She retired.
No, immediately after service, we get it posted.
Item 14.
Gratuity matter, similar matter already issue notice.
Issue emergent notice. Learned DTA, Shri Mohanty is requested to accept notice for the respondent. Call this matter along with WP number.
20845.
Write down and give that. Give that copy.
55. Well, it's 15 instead of 25.
Yes.
Item 15.
Matter related to aggressive matter, similar matter already.
This learned DTA call along with WP number. Give that.
Item 16.
Yes.
Matter related to revise the pension matter. Similar matter already. Revise.
Representation is given.
No, already similar matter issue notice.
Issue notice. Yes. Issue notice. 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 Call this matter along with WP. Yes.
Item 17.
The petition is acting as the in-charge headmaster at the post of headmaster. He has engaged the teacher. The law has already been decided that he is entitled to the headmaster scale of pay in Purnachandra Chand's case, my lord, which has been confirmed by the Honorable Supreme Court. But the district education officer rejected my claims just like an appellate authority, my lord. Under Annexure 5, he has passed a lengthy order rejecting my claim, my lord.
Will issue notice?
Yes,
Let him take notice. Issue emergency notice. Monthly on the preference of notice. Following notice. Follow ordinance. For paying of contrary fee.
Item 18.
I'm challenging the rejection ordered by the Annexure 16, letter 4/6/2020. The petitioner claim for the promotion, acted promotion, as per the order of the land set and which is confirmed by the Honorable Apex Court. But by the Annexure 16, the OP number 2 has again rejected my case.
Issue emergency notice. On the accepts notice for the respondents. All private or
No, all are government. Yes.
Government.
all of 4 weeks to file for filing their account. Repeat that. Okay.
Item 19.
19, my lord, yesterday one matter, my lord, of disposal of an item. That was at item 17, identical matter. I didn't get the copy. Item, that is WPC 22989. That fixation of RACP, my lord. Yesterday, that was there, the Sambalpur invention, my lord, took disposal of that representation. A place representation like that.
Same. Who is the OPs or who are OPs?
Similar to Sambalpur, same identical cases, only 2 cases.
They should be represented. No, let notice go in.
No, my lord, have disposed of other case yesterday.
In some cases, I have done it's true. But I feel whenever
yes, because my lord have disposed of that the same matter, one order.
Issue matter.
Other one is disposed of. That is why.
Item 20.
My lord,
Item 20.
my lord, similar matter has been decided according to Lokanath Veda. This the case is about reader placement.
Reader scale. This matter is not put in appeal. Not yet. Reader scale which I decided. Not yet. Any appeal is filed against?
Not yet filed.
Not yet filed. But just take notice. You make a statement based upon the DG requested for sub notice for the spot.
24 also similar. My lord,
Next also same. Huh? 21 also same. Okay.
22 also.
21, 22. 22 also. Okay. We can call them together, na? Call the 20, 21, 22.
Yes.
Okay, together.
Item 23.
Lordship, that teacher transfer case on the ground of the recommendation of MLA MP. A similar order has been passed. If Lordship shall pass an order, Lordship.
Issue emergent notice. Learned AG Shri requested to sub notice for the OPs. First up, Learned Counsel for the petitioners submits that in identical matters this court had. We have disposed of the matters.
No, Lordship. It is pending notice issue, Lordship, and stay is operating, Lordship. In all order has been stayed, Lordship, transfer, and they have been allowed to continue the LRC.
Counsel for the petitioner submits that in identical matters, reprieve has been granted to the litigants, and therefore the same benefit should be extended to similarly circumstanced petitioners here. First, there is force in this submission. Inasmuch as this court has granted reprieve in WP number
20875 of 2025, Lordship.
20875. 875.
5, Lordship.
Of 25.
25, Lordship.
25. In WPC number 20875 of 2025, this court has already granted reprieve, and therefore that cannot be denied. Similar benefit cannot be denied to the petitioners. First, next part, in the above circumstances, improved transfer order stay in a state and state coupled with a direction to continue the petitioners in the same place wherein he or she was working. But before the issuance of impugned order, till next date of call this matter along with WP 20875 of 2025. What's all other matters?
All are separate. All are by the instruction of the Lordship, local ML and MPs, Lordship.
No, it's all right. We said that. Which are other matters?
Others, Lordship.
Give that second week of
second
September.
Okay, whether in this matter we have said that.
Lordship.
Okay. There is one Karnataka division bench decision last week holding that transfer at the instance of MLA MPs is not bad. Just looking. There is Pandit and another judge has said that. Okay.
Item 24.
I think Goa bench of Bombay High Court also has taken the same view.
Policy decision.
So
Supreme Court has also
taken that view, no. But I have not seen that judgment. Yes, you have expert. Let us see. Just look into.
Yes.
Here in this case, I am also challenging the order of transfer. In 2013, my lord, petitioner was appointed as a clerk, annexure 1, my lord. In 2021, petitioner was transferred. On 4th of February 21, petitioner was transferred and posted to BES Saliapadam. Again, my lord, 2022, again petitioner was transferred by annexure 3 on 10th of June 2022, my lord.
Why you are in so much demand?
I said that I cannot say, my lord. But that transfer order was challenged by the petitioner before this honorable court, my lord. Since there is a vice versa transfer, another person was posting. Even the direction was given by this honorable court to director, you verify examine the grievance.
Director passed an order since petition has not completed minimum 6 years. You consider. Thereafter, but another person who was faster in my place, he challenged that order of the director before this Honorable Court. And the Honorable Court says, you leave the place because another person has already been relieved. Again, my lord, 2025, I have been transferred, my lord. Annex 10.
It appears you are very much in demand. Now, issue emergent notice. Learned AG is requested to accept notice for the OPs. First class. Learned counsel appearing for the petitioner draws attention of the court to the IA number.
IA number, my lord.
11545 of 2025.
My lord.
Supported by affidavit wherein he has sought for grant of reprieve. First one. He also draws attention of the court to various litigations in which the petitioner, various instances wherein petitioner was subjected to transfer even before the retention period was completed. First now, next paragraph. In view of the above, the case is made out for issuance of interim relief, protection, and accordingly, IA having been favored, there shall be stay of impute transfer order for the petitioner.
9 and 10.
Right?
9 and 10. Annexure.
At annexure, pursuant to annexure 9 and 10. They relate only to you.
My lord, only. This is only.
Then qualification may not be. Yes.
Since all other cases, my lord directed, allowed to continue, my lord.
Stay first. Further, an interim direction is issued to the office to continue the petitioner at the place wherein he was working before the issuance of impute order.
My lord.
Next date of hearing. Call this WP along with the WP 2087. But this is not
That's the
Item 25.
Please, your lordship. Lordship, there is some typological mistakes in the cost title. That's why I'm filing a amendment petition. Kindly.
I will permit you. You have made oral application, or you have application also.
No, ma'am. It is ready, but notary and.
Call next week. 2 weeks.
Lordship, kindly list tomorrow.
Tomorrow.
With amendment.
Yeah, but your application is not ready.
Lordship, there is not signature of my senior.
We'll call it day after tomorrow.
Published.
Item 26.
May I please, Your Lordship?
Yes.
But here, the claim of the petitioner is that his claim for pension has been rejected by the District Education Officer Ganjam on the ground that his services has not been regularized. He has continued till his retirement on ad hoc basis. My lord, that this finding is contrary to the documents which was filed before the
regularized.
I have, Your Lordship, may kindly come. And they had, my lord, I have given promotion under the cadre. They had issued the.
I am fully convinced. Still, you want to argue?
No, my lord. They had my interim prayer is that since they had already allowed me the provisional pension, so that may be I may be allowed to enjoy that, my lord. I have retired since 2022, my lords.
Within 2 weeks, you have patience to wait for 4 years. You have no patience to wait for 4 more weeks.
All right, my lords. As your lordship pleases.
Emergent notice. Learned AG is requested to accept notice for the OPs. First now. Petitioner's prayer for interim relief would be considered on the next date of notice. In the meanwhile, OPs may file their objection counter, if any, failing which the right to file one stands forfeited. First off, call of propose.
All right, my lords, kindly grant 4 weeks time.
Yes, I have granted. Final it is. Though rule says only 1 week, I am granting you 4 weeks, but final. Yes.
Item 27.
21, my lord, similar item of 23.
23, my 23. Yes, issue. AGA. Yes, Yes, it is relieved, my lord. Yeah, he has been relieved with effect from 11th July 2014. 11th July he has been relieved now. He is working in that school. He is not working in the school. Page 34, my lord. Have a glance, my lord. Yeah, on 11th July you have been relieved, my lord. Now more than 1.5 months over now. That notice, let me take notice, my lord. Notice, here such notice for the notice. And brings to the notice of course that petitioner has already been released on effect from 11/7/2025. First time, the same is noted. Next, call this matter after 4 weeks. In the meanwhile, OPs may file their counter if any, failing which signs. Okay.
Item 28.
May I please also. The petitioner has prayed for antedating of his regularization.
Well, we issued a similar matter. We issued notice already.
But this case is squarely covered by the judgment of this Hon'Ble Court in the case of Balabhadra Maji. Well, the petitioner was initially appointed as a...
Correct, but notice has to go to them.
My lord, I have made a representation to the director.
If you will be happy.
Yes. Let my representation be considered keeping in view the judgment of this Hon'Ble Court.
The short grievance of the petitioner is reflected in the prayer column of the petition as a first. Next, be seated. Kindly be seated. Learned counsel appearing for the petitioner submits that the claim of the petitioner squarely falls within the parameters of Balabhadra Maji.
WPC number 15345 of 2000.
Just right time. Yes. Balabhadra Maji versus State of Odisha, WPC number 15345 of 2022, decided by a coordinate bench or division bench? Coordinate bench of this court by the order dated 11/11/2022, and that the same has been affirmed by the division bench in writ appeal number 1912 of 2023, disposed of on 26/4/2024.
Writ appeal number 1752 of 2023.
It's not 194, 1912.
1912 actually 20.
But you have written 1912.
Second, third paragraph.
May not be correct.
That is, my lord, WA number is 1752 of 2023.
Then you rectify that.
Yes, I will rectify.
Right now that we are rectified. Next paragraph. Learned counsel also submits that his client would be satisfied if his application, his representation dated
7/5/2025. Addressed to the opposite party number 2.
Addressed to OP number 2. That's Annexure 2. Is Annexure 5.
Yes. Representation is at Annexure 5.
Annexure 5 is considered in the light of the said decisions in a time-bound manner. First up. Next paragraph. Learned AAC on request appearing for the respondent very fairly agrees to instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation. If a reasonable period is granted, reserving all contentions of the parties. Learned counsel appearing for the petitioner is petitioner submits that his client would be satisfied if that is done. First up, next paragraph. In the above circumstances, petition is disposed of and granting a period of 6 weeks to consider the subject representation in the light of the decision cited. First, all contentions of the parties are kept open. Decision taken on the said representation shall be communicated to the petitioner in writing within the said period as well. Full stop. Now, no course. I'll open to solicit information, etc. Direct to submit the representation of the. It is there already. Yes, madam. It is already there.
Yes, already there. Item number 28.
Yes.
Item 29.
When you wanted to amend that.
Yes.
Mr.
Your Lordship may permit.
In the separate order. On request is permitted to rectify the date in the date of the division bench order.
Yes.
In writ appeal number so and so. And he has effected the repair with leave of the court.
Yes.
Next.
Item 29. Well, petitioner is claiming his notional promotion. In the meantime, he retired, my lord. In view of decision of this honorable court directed the authority to consider his case after his acceptance of BED certificate. Petitioner got the BED certificate 2022. They have not accepted it. He filed the writ application before this court. This court directed and they accepted the BED certificate, man.
Yes, accept that notice. Issue emergent notice. That the ASC on request accept notice for the notice. All private parties.
All government.
All government. For 4 weeks for filing of a counter, failing which right to file stand party. Yes.
Item 30.
My lordship, kindly pass over item number.
Pass over. Just come here. I'll assist you. Start. Take that file.
My lord, on behalf of Mr. Mahapatra.
You don't have file?
No, my lord.
I will give you file. Just give our file to it. You turn the page.
My lord, I am just not junior of Mr. Mahapatra.
In any case, my lord, notice to go.
Emergent notice.
Certificate has been.
AGM Mr. Lenko accepts notice for OP numbers.
All the opposition.
All OPs.
Item 31. May I audible, my lord?
Yes.
Item 31, we have filed a joint counter, but it is required to file a fresh counter in the future. Today we have ready. We are today also filing. We'll serve the copy to other side. Let's may keep it to after next week.
My lord, I have filed the miss case releasing the salary. I am not getting since April 2024. No, budget has been placed. Budget is annexed 7 if your lordship find, and they have also said let them file counter. I don't have any grievance, my lord. Only thing what
it is a case. I am just clarifying, my lord. It is a case which is appointed by the UOT for a particular scheme for a particular year, 1 year. And this he is claiming that IMD should pay. He is no way concerned to the IMD. He has implemented paying. That affidavit today we are filing. Let my land friend go
through. I am praying, my lord.
Thereafter.
The government next week. The university has said
next.
Counter matter with copy to.
Yeah,
yes, definitely. Today our filing also copy will serve to you. Yes.
Next.
35.
25.
Yeah.
We have filed the rejoinder yesterday. Probably it has not come on record. And we have also attempted to serve a copy on the learned central government.
I've not received the copy.
Have you attempted? Next week? Next week.
Any urgency is there?
They are not stopping. After 1999, we were licensed guides and we were functioning, earning, eking out our livelihood. Then suddenly, the last week or so, 10 days, they've stopped our entry into the Konarak temple side. And they're asking us to buy tickets and get in, charging. But we were licensed guides. We had a license issued by the tourism department. Then the central government tweaked the guidelines to our disadvantage. So but still our application for renewal were not considered. But they allowed us to continue since we were bona fide and continuing. It's a question of livelihood. So can we have it next week, if your lordship, because in the interim now we are all affected. Any day but 11th?
Oh no, 16th?
16th, 16th. Suits my learned friend, 16.
16.
Great.
I'm sorry to interrupt, my lord. If you are next week only we have said next week any day. If you come, if it does not move, yeah.
Item 36.
Item 36, my lords, I pray for some time to file counter.
More than a year has happened.
My lords.
2 weeks for filing of counter final at the request of Planet AG. Yes.
My lords, 3 weeks.
4 weeks.
Item 37.
But I may be pardoned. But I have given the writ appeal number in another case. That was also upheld in the writ appeal. That was also upheld by the division bench. In the case of Pramodaman. So let's simply kindly see that. But so far as Balabhadra Maji's case is concerned, that was also confirmed in the writ appeal, but that number I have not given.
Similar matter.
Similar matter.
Identical matter.
Identical matter.
And your
Pramoda Mahanti's case was decided basing upon Balabhadra Maji's case. And in both the cases, writ appeals were carried out. Writ appeals were carried out.
Representations?
In the representation, I have mentioned Pramoda Mahanti and Balabhadra Maji also.
No, which is that?
Annexure 5.
Annexure 5.
Annexure 5.
This is identical matter, which is that?
Yes, identical. That matter was decided basing upon Balabhadra Maji's.
That was we discussed up today on matter, na?
Yes.
We have that number.
You also kindly see. Pramoda Mahanti's case was decided basing upon Balabhadra Maji's case.
Change the date of representation and annexure. Okay. One more decision we have to say that latest judgment.
Yes. That I have heard in the writ petition and also in the.
This is followed in terms of.
Yes, in terms of Balabhadra Mahanti.
Same. Yes.
Item 39.
Item 39 before my learned senior begins, my lord. I am appearing for OP 4 to 9. I have filed counter yesterday, my lord. That is not common record, my lord.
Yesterday you filed for counter?
My lords.
Actually, it will be because the proceedings are complete.
Proceedings are complete, but the next 2 weeks, many matters we have posted. We'll call it after 2 weeks. All right. Not give this number. Call on.
23rd, my lords.
23rd? At the request of.
The entry order to continue.
You have entry order?
Yes.
Then why next week? We'll call it after 4 weeks. The second week of October. Entry order to continue. In the meanwhile, counter to be filed.
The counter has already been filed. I have filed for the private opposite party and state has also filed.
Next.
Item 40 has been approved. Item 41.
Item 40 is 40. 40.
So 40.
2 weeks time.
Yes, somebody took turn.
There was a little bit of urgency. Could we have it next week or something?
Urgency?
I would normally not disturb.
No, it's all right. But any urgency?
Not sure fix the day because our writ has been allowed. We were granted equal pay for equal work. There's a finding of the court. It was only a question of sanctioning of the funds by the central government as submitted by the Council for the OPEPA. Now the central government has given a letter in the meantime saying that funds are with you. We have already sanctioned it. You are supposed to disburse it. That was the only point. So if your lordship calls it on any day, Manoj, so 22nd or something.
22nd.
22nd? No. Grateful.
Yep.
Item 41.
41, my lord. In this case, petitioner prayed for
revised rear salary.
My lord. Differential areas on 6th pay revision, my lord.
They have denied. They have denied it now.
Denied by the government. All the appointing authority submitted the proposal and also statement. By the annexure 6, my lord, have a glance page 29. DO my appointee submitted before the director. Now the government denied that I am not entitled on the ground that I have dismissal from 2012. 5/8/2012, but I am not claiming that.
One sentence, don't pause in your language. Yes, Mr.
File counter.
File the counter.
No, not file counter.
You want to file counter?
Yes.
All right, 3 weeks for filing of counter final. Yes. Okay.
Item 43. Item 43.
What is this matter? Go to the paper. Correction of registration number, etc. Take notice.
Hon'Ble University.
You are also party?
No,
you are not party.
I don't file.
Emergent notice. Returnable within 4 weeks.
Item 44.
There are 44 afternoon as well.
Well, it's 44. Counter is ready. We'll file within 2-3 days. 1 week time maybe.
2 weeks for filing.
Yeah, date will fix to Mr. is on the way. This because his will has not come. So I told only possible and after launch it.
No, they are filing counter.
So next week any day. Next week any day.
15. 16. No.
Item 45. I'm sorry, my lord. Item number 30 I could not reach because of the traffic.
Item number
30, my lord.
38.
30.
30. What we have done in that? We have issued a notice.
There is an interim application because of the cancellation of caste certificate by the Tahsildar who has no jurisdiction. Multiple other proceedings are being initiated against me.
Pursuant to cancellation.
Yes, Your Lordship.
Madhuri Patil is not.
No, my lord. That we have in our state of Odisha there is a separate set of rule which provides that there must be a scrutiny committee who shall verify, and after that verification, cancellation, if any, that will be done. But here the Tahsildar himself has cancelled, who has issued the certificate.
He has no such power.
He has no jurisdiction according to the act which I have with me.
But Apex Court said, after considering the identical rules in Andhra Pradesh, that the person, the authority who issued certificate can cancel it if it is obtained by fraud or fabrication.
Yes, Your Lordship. But here,
versus so and so.
But here we have our separate set of act, that is the act provided in our by legislatory act and under the rule.
Serial number 30.
Serial number 30.
Serial number 30. The learned counsel for the petitioner submits that though the Tahsildar has power to issue caste certificate, there is a separate statute in the what is called that?
That is
namely
that is Odisha schedule. I'm giving this gazette that may be formed part of the record.
So, which does not clothe the Tahsildar the power to recall the certificates once granted. First off, he also points out that the collateral proceedings are being processed pursuant to cancellation of the caste certificate, and therefore the same needs to be interdicted. There is a force in this submission. Next paragraph. In the above circumstances, IA number,
my lord, 14729
of 25, supported by affidavit is favored, and all further proceedings pursuant to impugned cancellation of caste certificate are kept under suspension or interim till next week of here.
Once again, I'm sorry for
because of traffic, especially it is raining.
Heavy raining, my lord. All the lords are in suffering.
Well, in Bangalore also there will be rains, but not as heavy as it appears.
But in Bangalore there is a serious traffic.
The traffic problem is.
Yes. One has to take 1 hour for reaching 3 kilometers.
Correct. We have terrestrial problem, we have sky problem. Yes. Item 45.
Item 45, may I pray for a passover?
Passover.
I am for the petitioner for a passover.
You are not ready now?
Well, if your lordship wants, I can place Mr. Prabhupada Ratha, senior advocate, has been engaged, but
let him come.
Let it be possible.
Passover.
Good.
Item 46.
46, item
46.
Item 46.
None appears for petitioner. Call after 3 weeks to enable counsel for the petitioner to come and argue. Yes.
Item 47.
47.
Yes.
Short point involved, my lords. The state selection board was supposed to take instructions in the matter. And Annexure 11 is the impugned order. Your lordship at page 87, your lordship comes to the last but one paragraph. The petitioner, Sibaji Pradhan, belongs to LD, means locomotor disability. And Shri Abhishek Majumdar, bearing roll number 2BH05000405. Having so, has been recommended for government for appointment. In view of the fact, Sibaji Pradhan merits no claims, merits no consideration. This is what they said, that since somebody has got a higher mark, he has been recommended and you have not. That's the reason. Now your lordship may kindly come to the order just before that, page 84. This was the affidavit that the state selection board files when I had, on an earlier occasion, round 1, I had prayed for declaration of the results, page 84. Your lordship, the paragraph 3, second paragraph, your lordship may drop down to the middle of this italics. So far, somewhere in the middle of that quoted portion, so far as the other 2 vacancies are concerned, one candidate bearing roll number, sorry, this is the same roll number of Abhishek Majumdar in the order, has been recommended for appointment and being authenticated by the appellate medical board already appointed as lecturer in commerce. So, only one post under PW, the LD category is now available. So, if one post is available,
that post, non-LD person could not have been appointed, though he has not merits that.
No, that post was vacant. They say that even if you are an LD, so one post is available, we will consider. On that basis, the writ petition was disposed of. Because one we have already granted higher mark to one candidate, that is Abhishek Majumdar. As it turns out that this man is Abhishek Majumdar in the order. So one post is there. But in the final order, they reject my claim saying there is no other post. So that is the discrepancy. Either the state selection.
The only thing is, if you
that
say,
is the only point.
If you say that there is one such vacancy, everything will be over.
Because multiple disability, the 3 posts, one was hearing disability, one is multiple disability, one is LD. So my contention before the High Court was, if multiple disability, they also admit that there is no other candidate available. So 3 posts. So my contention was, if it is hearing, then hearing one candidate was available, he should get. And as you say, the department says, LD there was one post with a higher mark, he should get it. I have no difficulty. There's one more post. So why should I not get it? Why should that post be vacant? That is the only limited point. Very limited point. And there is no other contender.
But anyway, let him ascertain it and come back.
Get back to your lordships. Let's get back to your lordships.
At the request of Learned AGA Mohanty, call this matter on 30th.
30th balance.
Yeah.
On OP4, Mr. Mohanty should take instructions from the state selection board.
Yeah, also appears for OP number 4.
Grateful.
Item 48
is Samir Das. Samir Das, Mr. S. Das.
Samir Das for OP4.
Samir Das is for this. Samir Das,
State Selection Board.
State Selection Board, parent. Samir Das was appearing.
Is it?
Mr. Das was appearing on the last occasion. So if your lordship directs, I'll serve a copy on Mr. Das.
I cannot.
To enable him.
I can only request Das to appear.
He was there.
No, he was just there. I'll serve a copy on Mr. Das. Since he was the counsel on the last in the last week.
And name is also reflecting in the order. It's a 10.
Order also, my lord, the name
Page
reflects.
82.
Mr. Das was appearing.
Okay.
Page 85 also.
But name is not reflected in the cause list. That is the
registry to print the name of.
No, he has not appeared, so it's not reflected.
Mr. Das is requested to accept notice for OP number?
OP number 4. State Selection Board.
State Selection Board.
Registry to
Secretary State Election Board.
Registry to print his name in the cause list. First one.
Grateful.
I call this matter on 30 September, and in the meanwhile, petitioner to serve a copy of the
13 September.
Yeah.
Grateful.
Petitioner to serve a copy of the petition on Mr. Das.
Grateful.
Yes.
Item 48. May I please, Your Lordship?
Yes.
Kindly permitted gives time to file extra copies.
Extra set.
Yes.
You are not furnished requisites.
Yes.
Or now you are furnishing the requisites.
Yes. Seems timely.
In earlier occasion, my lord sir directed to serve the extra copies. By that, the same is need to be
granted 2 more weeks for furnishing extra copies of the petition along with all the documents to the learned AG. Yes. Finally. Call after 3 weeks. Yes.
Item 49. 49 amendment. 48, 49. Same. Yes, ma'am.
Same. Tag 49 to 48. Okay.
Item 50.
Please, Your Lordship. The petitioner prayed for the disbursement of the deducted amount from the gratuity after return.
Deducted 64,834 from gratuity. On what ground they have deducted?
The last occasion, my friend was saying that amount was.
Monty, why did you deduct? What is the justification? There is power to deduct. There is justification to exercise that power.
64,834 million. My lord, we have yet to take instruction because we have intimated to, but we have to file the affidavit.
3 weeks granted for filing of counter, filing which right to file one stands forfeited, and petition averments may be taken up with face value. Call up the forms. Okay.
Item 51.
Pencil matter. Block grant pencil matter. It's common.
So have we checked this matters when? 40?
51.
51.
18 September.
Yeah, that was before the division bench.
Before the division bench,
it was before 11th of September.
16th.
No, 11th of September. I remember somebody mentioned last month.
I have made a mention.
So we'll have this in October.
3rd week, Your Lordship. That's why Your Lordship posted. 3rd week of the September, Your Lordship.
Many matters has been posted to 3rd week.
Do you have a connected matter numbers?
Yes, madam. That I am giving in sleep, madam.
Call this matter along with WP numbers. Use that sheet.
It has to
Yes.
Item 52.
52.
Last time, Malord asked the government to, it is a covered case, covered by a decision. Condition will court Miller. That is reported in 2023.
Third RSCP.
Last time, Malord took it. That's a covered case.
Ashok Kumar Mahapatra.
Same matter. It has been posted to
Second week or third week of this month, my lord. Bunch of matters are there.
You are right.
Saying the ସବୁ ଯାକ post ହେଇକି notice ହେଇଛି. Bunch man.
On this matter.
ଆଜି ବି ଦିଟା ସକାଳେ ହେଇଛି.
Are there other matters? Any other matter?
Item 55 was the same.
55 also same. This also. Same matter.
Same matter. Same matter.
Call this case in the third week of October, along with the serial number 55. 55. 55. 54 also. 54. 55. 52. 52.
Item 53.
Yes.
Item 53, the petitioner who is the aspirant for the post of Hindi teacher. Pursuant to an advertisement of 2016, Your Lordship, he has earlier approached this Honorable Court. This Honorable Court, after verifying the vacancy position, that
what is that impugned order 13/125?
Yes, Your Lordship.
Annexure 11.
In the impugned order, they have rejected my claim, stating that
your claim for
the appointment under the Hindi teacher post. That
here, my lord, notice was issued. And we are to file counter, my lord. This is the second round of litigation. And it is the impugned order is at Annexure 11, page 66. That is my lord's.
Your Lordship, even my learned senior can also take note of that, because so far in the advertisement, I have applied against the district of Khurda. In the Khurda district, the vacancy position, Your Lordship, will find.
Is it district-based appointment?
Yes, Your Lordship. At page 54.
You file objections, Mr. Mantri?
Yes, please.
Let me just point out, Your Lordship.
Why point out very simple matters? What is that? On this matter, after 3 weeks, at the request of the letter A, Mr. Mantri, for filing of order. Finally.
A similar matter is also pending before Your Lordship's board.
Which is that?
There is WPC number 20550 of 2025.
20550 of 2025.
I'm much obliged.
Fixing it to 2 weeks of
3 weeks.
3 weeks.
For filing objection.
Yes, ma'am.
Finally.
Yes.
I'm grateful.
But in earlier 2016, since last 9 years, candidate is fighting. Yes.
The order of rejection is of 25.
No, but earlier round of litigation.
Second round. First round of litigation is
2016
there.
matter. Okay.
I'm great.
Item 56.
6, madam, actually to regularize. Last order say issue notice, counter not fine.
File counter, madam.
more than 20 years of service they have completed.
No, Milord, here it is ready, Milord, counter.
2 weeks. For filing of some.
Only to file it, Milord.
Interim order continue.
Interim order is there.
Mile.
Interim order to continue, follow up to 6 weeks. Okay.
Mile. Table 6 weeks.
Yes, you have interim order. Any counter process engine? Yes.
Item 57.
May I please, my lord? My lord, this case is the petitioner was appointed to the substantive post of principal cum secretary by Annexure 1 in the on 25/4/2023. My lord,
25/4/2023.
And which was modified because the college has 2 branches. One is the degree branch, one is the junior branch. So why
you are appointed to which one?
Degree one first. Then they made it
that was rectified on
15/5/2023 to make me principal of both the institutions.
You became principal of
the entire college.
Earlier under 25/4 you were principal of degree.
So since there is one financial code, so for financial purpose, the DDO power was given to me of both the institutions. Well, there is this opposite party number 4 who had challenged my appointment, on the ground that he is senior to me. Therefore, this Honorable Court directed the opposite parties to consider the case. And considering the case, under Annex 2, the government took the very judicious stand that it's true that he might be senior in service, length of service. However, he is appointed as a junior college, junior lecturer in a junior college, the opposite but not 4. Therefore, he cannot be placed in degree college, particularly as its head. Now, my lord, on 2nd June of this year, they somehow transferred me from my college to another college in the post of principal in charge. From principal, regular principal, they made me principal in charge of another college. Whereas I am to retire in the month of November, and made this opposite party number 4 again principal in charge of my institution. I came before this Honorable Court, and this Honorable Court was very pleased after hearing the matter to quash the transfer order on the ground that it is unnecessary and less than a year is left, no point. Therefore, my lord, I was after the cancellation of my
degree college.
My lord. So therefore, now by that time, the opposite party number 4 has taken charge. And he took the plea that I will not relinquish because I am going to retire on 31st on this. He has already retired. Your Lordship had observed, your Lordship may kindly see the initial order. Your Lordship had observed that since it is a month of...
I remember. I told you that wait till he retires.
26, so that your Lordship will protect me from any other trickery by the opposite party.
Correct.
And your Lordship's apprehensions have come quite right.
Yeah.
The opposite party number 4 retired day before yesterday. He didn't hand over chairs to me. In the meantime, he has done something by giving an interpretation to the most judicious order of this Honorable Court that my salary should be stopped. That he has stopped my salary as well.
Who appears for the opposite party?
He appeared on that day. He has retired. They have no business. They have no interest in that nobody is here.
No, OPs are government.
OPs are government, but the private opposite party number 4 also.
OP number 4 is not before the court.
Not before the court. I saw the copy on.
Name is reflecting.
His name is
reflected in the court list.
Yes.
Who? Just telephone. Okay. Do you have phone number? We'll call it from our court.
I'm appearing through VC Matters.
Just give phone number.
I will find out.
And inform your friend also. Come after 2. So that, because salary is not paid.
The point, my lord, is that he has retired. If your Lordship directed, he should continue, the petitioner should continue because he
should get the salary.
That's what I'm saying. That's what, because salary now nobody can pay. Because that person has retired, nobody has DTO power except me. So only if your Lordship gives effect to the order of this Honorable Court that I should continue till my superannuation in my previous post, then the matter is solved. That's the only.
Let us bring your friend.
Well, I am appearing through virtual, my lord, sir.
Yeah, 58. Admission method.
Told that.
Yes.
For my on deliver pass over 59 pass off.
Yes.
Item 60, it may please rulers.
Order of the State Education Tribunal, which is completely, my lord, perverse and without any basis.
Yes. What is that order?
Order is under annexure. Annexure 5 at page 23. Completely, he has not taken into legal provisions at all for passing that order, my my lord, I have given a date chart earlier, last date, my lord, it was
release of block grant.
No, I want that the grantee shall be released in favor of me from
It's 2016-94. In place of my lord, 28-694 in place of my lord, that order has been directed to give me 1/3 from 1/6/2003 and 2/3 from 1/6/2005 and salary cost, full salary cost to 1/6/2007. And I have prayed that I may be granted that 1/3 with effect from 1/6/1994. And further, the 2/3 and third full cost after 2 years each time. Here what happened, my lord? In 1980-81, Gop College was established, my lord. Gop in the district of, the place name is Gop. And that college was opened in the year 1980-81 and affiliated. Only
who is your opponent?
Opponent is the state.
State. Ready. Next one.
2019, on that note, twice they have taken time for preparing the matter.
He is seeking 1 week time.
You'll also fix a date, my lord.
Yeah. No, 17th.
24th.
17th.
17th. Because my lord, why I am playing my lord? He has already retired. He is not getting his pension.
Yes.
Item 61.
But here I have challenged the order passed by the State Education Tribunal. Your Lordship may, for a moment, Your Lordship may kindly see the order passed by the tribunal at Annexure.
What was that? Why you went to tribunal?
Well, I was appointed against a trained graduate post on 27/6/1988.
27/6/1988. 88.
At the time of my appointment, I was an untrained graduate.
As untrained
graduate, my qualification was B.Ed. My qualification was only B.A.
BA. Therefore, untrained graduate.
Untrained graduate.
That means without B.Ed.
Without B.Ed. I acquired B.Ed qualification in 1994.
And
these are all undisputed facts. These are all undisputed facts.
No, you became trained graduate.
I became a trained graduate in 1994.
94.
Since my appointment was not approved, I went to the tribunal. I made a representation to the authorities
saying that you should be treated as a
trained graduate teacher and my appointment should be approved against a trained graduate post.
Yes.
But the tribunal, by a non-speaking order, Your Lordship may kindly turn to Annexure 8 at page 23, rejected my GIA case or dismissed my GIA case on the ground that I have not filed any document to show that I was regularly appointed in that school. Your Lordship may kindly come to page 23, Annexure 8.
The short order.
Short order.
Say no material to vouch your claim.
Yes,
that
yes.
you are regularly appointed.
Yes, yes.
Any material was produced?
Yes, yes.
What material was produced?
My lord, here I have given, my lord, I have not annexed the GIA case filed before the tribunal, but here I have annexed. Your Lordship may kindly see.
There is one decision of the apex court.
Yes.
When a grievance is worked out or sought to be worked out before a statutory tribunal.
Yes, it's a statutory tribunal.
Yeah. All documents, including pleadings before the tribunal, should be made part of the writ petition.
Part of the writ petition.
So that this is 227.
Yes, yes.
This is 227 petition.
227.
Because the order of the tribunal is being examined.
Yes.
Unless you say tribunal itself has no jurisdiction.
Yes.
Therefore, if all material is given, where is the evidence to show that you were regularly appointed?
Yes.
That's the only point.
Yes. Your Lordship may kindly see, my Lord, so far as appointment order is concerned, I have not annexed, but the resolution in support of my appointment, because the resolution is the most vital piece of document, because I was appointed during the unaided period. And during unaided period, the managing committee is the competent authority to appoint me by passing a resolution. And pursuant to the decision of the managing committee, an appointment order will be issued or followed.
Where is that order?
My Lord, appointment order I don't have because she has lost. But so far as the resolution of the managing committee is concerned, that is available under Annex 2.
No,
that is in vernacular.
Two things are.
My Lords.
Resolution is the decision to appoint. The factum of appointment is evidenced by the appointment.
Appointment order, absolutely correct. But I have also annexed a certificate issued by the Secretary of the Managing Committee, which shows that I was appointed on 27th June 1988. Your Lordship may kindly turn to Annex 1 at page 11. 28/7/1990, that certificate was issued by the Secretary of the Managing Committee. This is to certify that Srimati Ramamani Satpathy has been serving as an assistant mistress of this school since 27 June 1988 and is continuing till date.
No, it does not say on regular basis you have been appointed.
My Lord,
that was the question before that.
Yes. My Lord, that will be reflected from the resolution of the Managing Committee, because the resolution of the Managing Committee is the basis for giving me appointment. If your Lordships will look at the management rules of 1991, my Lord, this is a high school. My Lord, may kindly see 1991 rules. High school.
Now the school is a aided school.
Yes, it has come into the fold of granted it.
Who appears for the school management?
My Lord, the school management, nobody is appearing perhaps.
You appear for the school management?
No,
headmaster.
Yes.
You are appearing. You are headmaster.
Headmistress comes secretary. Because after the school became an aided one, as per the 1991 rules, the headmaster is the ex officio secretary of the managing committee.
Okay. What do you say whether she was employed or not?
My Lord,
that's the only point.
My Lord, she is not employed, my Lord.
Not employed. But where is your statement of objections? Your counter?
I am appearing. Let me 2 weeks time given to
no time. 2000 which year matter?
In the tribunal, my Lord, no counter was filed.
No counter was filed in the tribunal.
Yes.
But did you produce all this material before the tribunal?
Yes, my Lord, yes.
Where is it stated that you have produced all this material?
If you
has not been looked into by the tribunal.
We
are examining tribunal's order in the material.
I am conscious of that. My Lord, in this case, what has happened? My Lord, a writ application was filed before this Honorable Court. That is OJC number 17786 of 1997. That was transferred to the Learned Tribunal under Section 24B of the Orissa Education Act 1969. My Lord, may kindly look at page 5.
Because of 24ABC.
24B. B. Okay. Because the alternate remedy is there. So far as the granted dispute is concerned, it is to be adjudicated by the State Education Tribunal. Therefore, that writ petition, that is OJC number 1781776 of 97, was transferred by this honorable court.
The petition itself was transferred.
Yes, by order dated 7/1/2008. That petition,
all materials
that
available.
petition is there. Your Lordship may kindly see. I was not the conducting counsel, but my lord, I have quoted that order of this honorable court at page 6.
Brother, what you had not taken up any stand before the tribunal. You were a party before the tribunal because you were a party before this court. At that time, you were a party.
Yes. State government and their functionaries were parties.
You produce original records. You produce original records of the institution. If secretary says that she has been appointed, and she has produced the resolution, how can he say that she is not a regular employee? That's the only point. No objections are filed. At the time of what is the private management?
Management was there, but the management did not choose to file any counter.
Here also you have not filed any counter.
No.
Did you appear there?
Yes. I am appearing for the headmistress. Headmistress is no way concerned with the matter.
Why? She is your secretary.
Secretary or headmistress.
You have to say on this particular. See, she claims that I have been appointed as the TG.
Graduate teachers.
My lord, I have collected the documents and also the information from the headmistress at least 2 weeks time.
Well, all these years you have not done.
2019.
And the matter is pending since 97. Well, the writ petition was filed in 97. It was transferred in 2008. I have quoted that order at page 6.
Call this matter on 9/9 at the request of the counsel representing the secretary of the institution and also ASC representing the official office. Fine. Yes.
Item 62. Item 62. I refer one time ballot. To the state employment.
Right. We are taking all these matters on Thursday.
Yes.
9/9 will have that.
Item 63. 63.
Well, let's say paper and passover on behalf of Mr. D.
And passover?
Yes.
Passover.
Item 64.
Yes. Well, in this case, I am the sole respondent. Respondent number 1.
Can I
succeeded in the tribunal.
Can I return within 3 minutes?
Yes.
That's
Confusion the list that item 37 has not been called. I am there. This is not as I have been told by my courtmasters.
Your name is not reflected.
No, my name is there, but they have said it is covered by another case. This is a separate case.
Separate case?
Yes, my case is
Yes,
separate.
it is different.
That may be called. May be called.
37. Yes. That's the preceding matter, 36 matter. 36 plus 3, your lordship may kindly see that is adjourned to 4 is after. So matter not so where I am at the purge of retirement and I have. When are you returning? Retiring? In the month of April minutes. What your retirement means? It is 7 months only. So for that, map them, say lordship, your lordship may kindly fix up a date. That apartment's noting is with regard to 3 extra. Not sir. Now already order is passed. If suppose if it does not come after 4 weeks, you move a memo, I take up. Okay.
मैंने 46 आइटम में थोड़ा लेट हो गया, थोड़ा
लेट हुआ. Who is your lawyer?
I am in person.
You want to argue in person? Your matter is 37. 37. We'll take this, then we'll take your matter. Okay. But he has to bring the lawyer not. Unless he terminates Wakala, we cannot be permitted to. Yes, still. Interesting. At least tell him you were licensed to bring his lawyer. Otherwise, he'll be waiting like that under the impression that I will hear him. आपका वकील साहब कहाँ है?
In person.
In person.
There is edit in person. But some lawyer you have in somewhere.
Okay, I have engaged some lawyer, but he is not as there today.
But then you can't argue like that. Only lawyer can argue, not you. You remove that lawyer and I will hear you.
Okay.
Then you can't do that. You have to issue notice to him. You have to settle his fees. Then he will give no objection to you. Then you can appear.
Because some issue I am not receiving no objection. Any other option available, my lord?
At least bring a lawyer. You bring that lawyer here.
I am able to argue.
You may be ready, but he should permit you because you have already engaged him.
But he is not coordinated. If he is not coordinated, then what happens, my lord?
You can't make allegation against a lawyer in his absence. If you say that, people will be looking online. If you say my lawyer is not
any short date give, I am arranged. Any short date give, I am arranged.
We'll have it on 23rd.
Okay.
Which place you are coming from?
I am from Kordhan.
How many kilometers?
It is around 80 kilometers.
80 kilometers. What is that? 23. 23 already?
Okay. This month, my lord?
This month 23. We can't travel back now. Yes.
Essentially, this is a case for arrears salary of the person who is now retired. 37.
Yes, Mr. Master.
This is my essence claim here in this case is the arrear salary for the period from 1/8/2006 to 7/12/2017. That is my essential claim. Now I am retired. The fact of the case, I have filed a written note of submission and the chronology of facts because this matter relates to good number of litigations right from the directorate, inspector school to the Honorable Supreme Court. But all the occasion I have succeeded. But for the fault of the authorities only, I could not join. Though my order of termination was set aside way back in 1/11/2007.
1/11/2007. You were appointed on.
I have given a chronology date of events.
You have given.
Yes, that is there on record.
Chronology of events.
I have given because these are the I'm giving another copy. I'm giving another copy. I have one copy.
No, what happened is file is sent back.
Oh, sorry. Then we keep some other day.
That's what.
Convenient.
Which date we have put there? The order is made already.
No, they said this point of. That is a mistake.
So it is not identical.
That is the way I
take it. Take out that one. Okay. Next week we'll have that.
Yes, sir. Any date convenient to my.
My lord, there is reference to number of cases, orders and judgments. I request my friend to supply the copy of
set of them.
I am giving it now. You have it.
Along with the chronology of events.
I have given it. I have given a copy also. I have given to the court as well as to my
because this is
it now.
my lord.
Government GA acknowledges receiving all the papers
for the court
hands of counsel appearing for the petitioner. Petitioner. This is our copy.
Yes, madam. Record.
For our record purpose, keep it along with. No, same day you give that.
Yes, otherwise file is not. Yes, it not.
Put some. Which year matter it is?
Lord, if you go back, this is a case
24.
97, sorry, 1997, I am fighting out litigation.
We'll have it on 24? September. September 24. Fine. Yeah.
Yes. Item 64?
But in this case, I am for the respondent number 1. I succeeded in the tribunal. The tribunal directed for approval of my appointment against the post of junior clerk. But that order is under challenge in this honorable court by the state.
Petitioner?
State.
Yes, sir. What ground challenge?
I think may take it up 9-9 cross day ballot.
9-9 at the record. All or not 9? Wait.
No 9.
16-9. That day you should be ready, my lord.
Small very short point is
matters.
Very small points for short point is involved.
No. Yes.
Item 65?
Yes. You appear for 63. 63.
So this pass over.
You done. What is this matter about?
My lord, I am challenging the order of the tribunal, my lord. The only grievance by my case was rejected.
Your case?
I approached tribunal for approval of my appointment for the purpose of release of block grant as per granting order 2008. My lord, I was appointed in 1996 as a lecturer in second post.
Can you give the date?
My lord, 23/7/1996. As a lecturer in history, second post. I joined on 6/8/96.
(26/8).
23/7/96 I was appointed.
Appointment order.
Joined on 6/8.
6/8.
My lord. By the time I was appointed, the institution status was an unaided, recognized institution. So governing body was the competent authority to issue appointment order in my favor, and accordingly appointment order was issued.
It was aided institution.
It was unaided, recognized.
Unaided, recognized.
Recognized.
What is meant by that? What is meant by recognized? State recognized.
Government granted permission and recognition in favor of the institution where student can appear in the examination if it is a recognized institution.
No, otherwise not.
First, the institution got permission to establish. Thereafter, institution applied for recognition. Government granted recognition. Concern university or council granted its affiliation. Thereafter, students appear in the examination concern university or council, whatever it may be.
Okay. That's the scheme.
Well, that is this process of the institution is to establish and got permission, recognition, and students to appear.
Under Odisha
Education Act
1969.
1969.
Okay. So 23/7/96 is date of appointment.
My lord.
You reported for duty on 6/8/1996.
My lord.
Correct?
My lord.
Then what happened?
On my lord, 13/8/2011, the institution was notified by the state government as an aided educational institution.
It's called GIA Institute.
GIA, as per section 3B.
Yes.
One Satyajit Kumar Patnaik was appointed on 18 March 1994 as a lecturer in history, first post.
Your second post.
I am second post. His appointment was approved by the competent authority for the purpose of release of granting aid. I have no dispute over that matter, my lord.
Yes.
Satyajit Patnaik, my lord, while continuing as such, he died in 2012. That is, my lord, on
13/8/2012.
2012. He died.
So on 14/8 vacancy arose.
14/8 vacancy arose. Governing body took a decision that elevating me from second post to first post the vacancy which was arose after the expiry of Satyajit Patnaik. So thereafter, my lord, I approached the Learned Tribunal by filing a granting aid case. Since post of history lecturer post, which has been approved by the and granting aid has been sanctioned in favor of Mr. Patnaik, who expired, and thereafter I was allowed to continue. My appointment be approved for the purpose of release of granting aid.
With effect from?
With effect from the date of my appointment.
You were appointed on?
I was elevated on 14 August 2012.
What is that elevated word?
Elevated that means since I was appointed second post, I was the other elevated word could not be proper.
Whether that word is used in your statute or your I'm asking, I want to know.
I was adjusted against first post.
You were appointed to?
I was appointed.
That's the first post.
I was appointed to. I was allowed to continue against first post in view of the resolution of the government.
Your question will not arise because you were not there in the first post.
No, I was not there.
So you were appointed to the first post.
Yes.
That was on
14th August 2012.
No, vacancy arose on that date.
On same date, my lord.
Where is that appointment?
That resolution.
One day they will do that.
My lord.
So fast, but nobody is shown that speed in my court at all by filing objections, counter, etc.
That is page 39 in that is the resolution of the governing body.
Governing body resolution is?
Page 39, that is 14 August 2012.
Very next day governing body met.
What's that?
Before the grave of the deceased became dry. It's in Oriya.
Oriya, my lord. If my fault, I can give a translate copy.
No, it's all right. That is 14/8/2012. Where is appointment orders?
No separate appointment order was issued, my lord. And page 43 is English. My lord, kindly see page 43 for a moment. That was the recommendation of the sub-collector to the director. If my page 43, my lord.
Sub-collector.
Sub-collector is the president of the governing body who recommended.
Ex officio president.
Yes, sub-collector is the president of the office.
That was in respect of history, second post.
Second post, it is, kindly see page 43, that is one Satyavan Sahu has been appointed in the second post of lecture history by the managing committee on 6/8/96 by imparting teaching history. As late S.K. Patnaik was principal in charge. The appointment order joining report proceeding of the managing committee are attached for kind perusal. In the context, I recommend the name of Satyavan South to be approved against first post of lecturer in Swanso College against the vacancy caused due to death of S.K. Patnaik. I approached the Lorraine Tribunal for my approval against that post, where Lorraine Tribunal directed the government to take a decision, and government rejected the same, dated 15th of February 2020, my lord. But can you see that order page 44, the order of rejection, last paragraph, my lord. Page 44, my lord.
This is approval for the purpose of granting aid.
For the purpose of granting aid in shape of...
Mr. Swain, is it for granting aid?
Yeah, granting aid in shape of block grant.
It is as per 2008 granted aid.
2008 granted JIA.
My lord. Government rejected page 45, my lord, kindly see page 45.
What is the ground which the government has said?
The
5 grounds have been given.
The most important, my lord, page 45. That the applicant was elevated to first post.
They use the word.
From that, I use that word. The applicant was elevated to the first post of lecture history after the death of an aided staff with effect from 14/8/2012. As per the provision under clause 8 of 6 of granting of 2014, the date of eligibility in respect of post in an educational institution shall in no case be dated after the 1st June 2008 in case of educational advanced district, and after the 1st June of 2010 in educational backward district and women's educational institution. The said elevation to the first post beyond the cut-off date of that is 168 or 1610, whichever case may be. In view of the above, the petitioner does not qualify to be considered for GIL 2014. So now
what is he saying?
Now they say that I am not eligible even.
No, that I have understood. You are not eligible because you are appointed in 2012. That is much after 1st June 2008 or 1st June 2010, as the case may be.
Now, my lord, can
you see the logic of this?
My lord, can you see that provision which was relied in 2014 granting order, page 1020?
In order.
In the education manual.
Education manual?
No. 1010 starts from 1020.
I have made my book like a rainbow book with all these colorful flaps. Which page I have to see now?
1024.
We are holding same book now.
Madam. Clause 8. Clause 8. 8. Clause 8. Very good.
8.
Subclause 4. A post shall not deem to be completed the qualifying period unless the post has been filled up on full-time basis during the entire qualifying period. The post has not been filled up on honorary or part-time basis at any time during the entire qualifying period. The post has been filled up by a person or persons recruited in accordance with the procedure laid down in the Act, rules and the instruction as applicable at the relevant time. D. The post has been filled up at all times during the qualifying period by a person duly qualified to hold such a post. Thereafter, can you see 6. The date of eligibility of a post for which granting it in shape of block grant has not been sanctioned shall be first day of academic year following the date on which an approved post complete the qualifying period as applicable to post, provided that date of eligibility in respect of a post in educational institutions shall in no case be date after 1st of June 2008 in educationally advanced district and be a date after 1st June of 2010 in educationally backward district and women's educational institution.
Proviso to rule sub-rule 6 is reflected,
my lord,
in clause E of the impugned order.
My lord. What I understood, my lord, subject to my lord, that if a person qualifying period completes by 1/6/2008 in an advanced district, then he by calculating 5 years qualifying period, that person must be appointed by 2003 according to the, because 1/6/2003 plus 5/1/6/2008.
No, what is meant by proviso to 6? Proviso is an exception to the rule. It is always treated as an exception, subject to some barring some exception. Now they say, if you are fitting into 8(4), okay, that is not end of the matter. You should travel up to 6, and you may travel up to 6, still you will be excluded if you fit into the proviso, because your case will travel to that proviso to 6. Therefore, not only compliance, you should also comply with the requirement of proviso. Because proviso, although it cannot swallow the main rule, it can remain as an exception. What they have said is, your appointment is post 2008 or post 2010, 1/6/2008 or 1/6/2010, whichever be the whether backward or advanced. Therefore, you are not entitled to is the version of the government.
But the language clause 4 says, a post shall not be deemed to have completed qualifying. So, my submission, the history post has completed the qualifying period by taking Satyajit Patnaik from 94 up to 2012. So, subsequent by complete the qualifying period is not required by another person who
subsequently comes to my
post. That is my submission, my lord. That is the point for consideration of this one, my lord. If a post complete the qualifying period by the cut-off date 1/6/2008, and person
there was already one incumbent.
Exactly. That is why language is there. A clause C, the post has been filled up by a person or persons. Clause C, my lord. 4C times C.
So it may be earlier person also.
My lord.
It need not be same one person.
My lord. Exactly, my lord. See, if the qualifying period is taken into a person or persons, and Satyajit Patnaik has completed the qualifying period, got the granting aid, and he died. And I was appointed. I should not go through another qualifying period for 5 years. In that, even nobody will get granted. If a person will die 4 years, and another person again will die 3 years after, in that process, nobody will get granted in my law. So my intention, post got granting aid, post received granting aid, and I was adjusted against that post. That is why my law. That is the case for
that idea of that qualifying period. Where is it mentioned?
My lord, that is my lord. Can you see clause 8?
a year. What is meant by that qualifying?
Qualifying period, my lord.
Where is it mentioned?
At clause 8, it starts clause 8(1). A post in a non-government educational institution for which no granting aid has been sanctioned prior to commencement of this order shall be eligible for granting aid in shape of block grant if the post is admissible as per workload and yardstick prescribed in this order Annex 2. It has completed the qualifying period of 5 years.
That qualifying period. What is meant by qualifying period?
A post will get granting aid 5 years after it got recognition. After recognition was granted,
Mr. Swin, what is meant by qualifying period?
5 years from the date of concurrence or recognition. 5, 7, and 9 for advanced areas, and 3, 5, and 7 for backward areas and for women's colleges. From the date of concurrence.
From the date of concurrence.
Concurrence means recognition.
Concurrence means recognition. So qualifying period begins from the date it is granted recognition.
The subject got recognition.
So it should be at least 5 years. It should have run after the recognition is the idea.
Yes. And it must have been, the post must have been filled.
It should be, of course, yes. Naturally. So it is like a doctrine of tagging in Transfer of Property Act, where you are counting adverse possession for a period of 12 years. That possession need not be by one person. Suppose if he inducts another, then there is called the doctrine of tagging.
Multiple persons.
It can be, that period will be reckoned from particular period. It goes on like that.
Right.
That way. So the earlier period, when that other person, Patnaik had completed all this, then that requirement will not apply to you.
No, that is my solution.
Because the word used is person or persons.
Persons.
Where is that?
4C. Clause 4C.
84C.
Clause 4C. Subclause 4C is that same page, 1024 page.
The post has been filled up by a person or persons recruited in accordance. Persons, it must be in series only. Because one post cannot be held by multiple people.
And the intention, the 5 years qualifying period, once completed, so another person, he is not required.
He need not again repeat 5 years for that purpose.
In that event,
no decision on this point.
The decisions are there with regard to that a post gets granted 5 years after it's got recognition. That decision is there.
Up to that.
Up to that.
But for a successive appointment, what should happen? That is not considered.
Yes.
No decision interpreting these provisions, Mr. There are decisions.
There are decisions of this Honorable Court because the granting aid is always paid against a post, not against an incumbent.
Okay.
If the post completes the qualifying period.
Post completes the qualifying period, it earns the granting aid. Yes. Whoever is appointed, he will be the beneficiary.
So far as the granting aid order of 2014 is concerned, because there are some conflicting provisions, because of that it has arrived.
They say granting aid is to the incumbent or to the post.
Incumbent. The cut-off date has been fixed.
This proviso.
No,
another proviso.
Another provision is there. That is para 3.
Para 3.
Yes. That is
an institution.
3.
Okay, institution, yeah.
3.
3. On or before 1st June 2008. Similar problem is there also. But it's in a different context.
In the
different context.
Because of this provision, they are creating problem.
Okay.
It said that if one has not been appointed prior to that date, they will not be. But granting aid is always paid against a post.
There are some Karnataka High Court judgments which hold the
Our judgments are also there.
They're there.
This very provision in para 3.3 is not there in other granting orders. But so far as 2015 granting order is concerned, it is there.
They have
that one must have been
incorporated this.
appointed prior to that time. Because of that, the problem has arisen. Even if a predecessor who completes the qualifying period, his successor will not be.
So because he also should complete is the version of the government. Yeah, what he says appears to be sensible. The word used is person or persons. Suppose that person does it for 3 years, and you do it for 2 years, then it will be 5 years only. That way. But if that person has done the entire 5 years, the other person need not do it, is your contention.
Post-mature.
That is a reason E. What are those A, B, C, D?
A, B, C, D, my lord, they say that the petitioner, they say that.
So A is not the ground. It only state the fact.
B said they accepted that I was appointed, they said that I was elevated. B. As he says, my lord, they say that as per 74 rules, governing body has no power to issue appointment order. I was appointed in 1996 when the institution was already honored institution.
It became in 2011, it got
a subsequent, my lord, they say that there is a ban dated 20th/4/98 has clearly directed vacancy of teaching, non-teaching post arising out of death, resignation, retired after 1/4/98 would not be filled up without concurrence of the state government.
We rules 1974. That becomes a ground.
Clause C, correct. They say that that 1974 rules
prohibits adjustment.
Governing body has no power.
Headed post by governing body. Which is that rule?
1974 rules, my lord. But I was appointed in 1996. By that time, the institution was an honorary institution, my lord.
No. You are appointed to the first post. That will be the focal point.
I was adjusted.
I meant by adjusted.
I was adjusted, my lord. By 74 rules. 74 rules say the governing body has no power to issue appointment order, that is fresh appointment.
Yes.
Then so governing body, page 976.
Which rule?
That rule 8.
Here also rule 8.
That exception to the selection by board.
Exception to selection by the board.
What does it say? It says, my lord, that notwithstanding anything to the contrary in this rule, it shall not necessary to apply or to submit any appointment made by the managing committee or governing body to the selection board if the appointment is made on
ad hoc basis.
My lord.
Then B, what is that B?
B says, my lord, a higher scale of pay. Vacancy in a post carrying higher scale of pay.
Means what?
Promotional post. Promotional post. So here they say in clause C that the 74 prohibits for adjustment, which is not available in the rules, my lord.
So, yours is no, they say cases which fit into 8 to A and B. They do not, you need not apply. It will, the management itself can make that arrangement.
Well,
other than that, board has to make.
Selection board. Selection.
Your appointment is not followed by selection board proceeding.
No.
Then?
I was appointed by the governing body.
That itself is bad.
That, my lord,
what he is saying.
They are saying. That
it does not say bad, good, etc.
They say.
You are entitled to aid.
My lord, they say my adjustment as per the 74 rules is bad.
Yes.
They say.
Correct.
But my submission, my lord, I was appointed in 1996 when 74 rules has no application.
Why?
Because this institution has the 74 rules applicable to aided educational institution. Can you see the applicability, the rule itself, the Orissa Education Recruitment Condition of Service Teacher of Member of Staff of Aided Educational Institution, the heading, my lord.
Correct.
It was notified in 2011 by the time I was appointed by the governing body.
August 2000. That was to the point of
thereafter I was adjusted.
Appointment is to the post. If you get what is meant by appointment, that Samaraditya Pal has dedicated one whole chapter on that. What is meant by appointment? Appointment postulates ordinarily selection. Is it not? Of course, with the exception. Straight away, without any selection, you can't make it because ours is a normative process. So there has to be some selection. Selection need not be very elaborate, etc. But at least somebody should verify that you possess the qualification. You have the requisite experience. Is it not? That you are a man, not a woman. That you are a woman, not a man. Because gender-based questioning, all those things are there. So there should be some selection process, number one. Number two, it requires qualification. Because it is not election, where anybody without qualification, anything, you can become minister, everything, but you cannot become boiler inspector. Okay. Then the appointment should take place. For that, there should be a post. And that post should be vacant. If these conditions, ingredients are there, then the word appointment, the idea of appointment has meaning. Otherwise not. Your question is that the word elevation, therefore I asked you, why are you using the word elevation? Ordinarily, elevation is used in respect of appointment. Well, of course, that word is absent in the Constitution. But anyway, by judgment, so first judge's case, second, the third, fourth judge's case, up to 8 judges' case, they are using the word elevation. Elevation to the High Court, elevation to the Supreme Court, or elevation from High Court to Supreme Court. It's not called promotion. It's a different terminology. But in service jurisprudence, you are appointed to a vacancy in a post because the other person incumbent died. Is it not? Therefore, that appointment needed selection by the board. That has not happened in this case. Therefore, you are not entitled to. You say, no, I was appointed, you were appointed, is true. But that was to the second post.
Subject to my second post, having the requisite qualification,
everything
process of selection.
Yes, you are most valid candidate in that.
So I was appointed to the post of lecturer, but two is a second post. While we are continuing, first post and second post both were continuing simultaneously. First post died. The person who holds the first post,
incumbent died.
Incumbent died. So my submission will be, because since, as my lord have seen, clause 4C, that the posts to get eligible, to mature for a post to get granted, since it takes persons, 2 persons, and I was appointed second post having the requisite.
No, it's not on that. We are not traveling to rule 8 at all. You are traveling to rule 8-4.
My lord. No, I'm not saying that.
I am on this.
I'm not saying rule 8-4 of the GIA order. I am saying, my lord, the taking me from the second post to first post, taking me from second post to first post.
1 second. You were in second post.
No.
You were appointed to the second post. Therefore, you were not appointed to the first post.
No.
All right?
No.
You were appointed to the first post. Therefore, you were not in the second post.
I
mutually exclusive.
I use the one I was adjusted to.
The problem is with the word. The problem is, therefore, see, when Julius Caesar, you have seen Shakespeare's Julius Caesar. After Brutus and others stabbed Caesar to death, there was one Antonio, a close friend of Caesar. He wanted to revenge. Then he made great speeches of Antonio. The people were mesmerized and they revolted against these assassins. And whoever is having name of Brutus, even they wanted to attack him also. Therefore, the words, there is one famous statement by Oliver Wendell Holmes. He says, a word is a skin of living thought. It is a skin of living thought. It has an idea. If we say animal, it goes to zoology. And botany is excluded. Understood? If we say living things, then zoology, botany also will come. In zoology, if we say mammals, non-mammals are excluded. Those who do not have mammalia glands are excluded. The lactating parts. If we say vertebrates, then invertebrates are excluded. Similarly, we understand by exclusion of things. From ant to animal, that elephant, that gradation, that's how the brain works. Therefore, we cannot use wrong word. If you use a wrong word, the transaction which you wants to happen will not happen. Therefore, when employing language, one has to be very careful. Therefore, I asked, where is that word found, elevation found in these rules? If we take that, it gives a rough idea. Elevation means from post 2 to post 1. It's not like that. It is appointment. Every post, somebody has to be appointed to. Is it not? Post is different from incumbent. Post is different holder of post is different. One holds the post by leave when he has properly selected and appointed. That's how it is. Take out this. This is discussed in by the Apex Court under the Office of Profit Cases. What is post? What is office? Who is incumbent? The relationship between post and the incumbent. This is discussed at least in half a dozen cases by law of elections by Chamar Bhagwa, Chapalgaonkar. He has discussed this first. Take out one judgment of the Apex Court, brother. Chandrasekharaya versus State of Karnataka. I believe that this has been discussed by the Apex Court. Chandrasekharaya, not Chandrasekhar. RAIH, something like that. State of Karnataka versus Chandrasekharaya. Not this. State of Karnataka versus Chandrasekharaya, but or Chandrasekharaya, Justice Chandrasekharaya versus State of Karnataka. Just see.
In the my lord, maybe sometime I'll examine it.
But I have understood now. They have no case. That the E is wrong. E, I am with you. The reason E, I am in agreement
that
with you.
E,
this comes in the way.
That my lord, why
it comes in the way.
Why, my lord, I'm playing for some time because E, if my lord will read E along with that a C, that rejection or a C, E says a post is filled up, not appointed. Because in that circumstances, if my adjustment will be treated as an appointment, a fresh appointment, in that circumstances the cut off date will be applicable. If my appointment, my adjustment will be treated as a fresh appointment by following procedure of law, then the cut off date which was prescribed in E will definitely applicable because I must be appointed by that cut off date. Because since I was taken as an adjustment, that is
that we don't understand.
Say that
word adjustment. No, that fit into the.
I will even sometime I will verify that.
My fear is I may forget all now whatever clarity I have got after hearing you and after seeing the provisions of the code, both codes. I may forget on that. Anyway, I have to satisfy you also.
No,
this matter.
I just say that because there says to be filled up, here it says appointment.
No, that makes no difference. There are judgments. There is no difference between these. But only thing is what is meant by Chandrasekharaya versus State of Karnataka. 11th April 2023, Karnataka High Court, Sri Chandrasekharaya, State of Karnataka. What is the citation? Not reported. Yeah, it is reported. I read, otherwise I would not have remembered. All right, look into it, come back. So judgment, just look into that book also, Chapal Gaonkar on law of elections. He has enlisted certain rulings in relation to this discussion. The book is available in the just thing, Chapal Gaonkar on law of elections. One word, Chapal Gaonkar. It's here. Landmark judgments on election law. N.G. Chapal Gaonkar. Yes. Okay. All right.
Item number 43 I have missed it because of I am on another code. It's my fault. Item number 43 may be had term launch manual.
We have issued notice.
No, already it is after notice matter. Inadvertently it was done.
After notice matter.
Yes.
Then we cannot issue again notice.
No matters.
Your opponent is present.
Sir, Lordship, my senior requests more time to file the count.
5 months have already 5 months. So short time.
We'll have it on second week of October. Which date? No investment. Because already after notice matter.
Last week of September can it be possible?
No, very difficult. Last week,
yes,
26. So therefore, we cannot say.
A particular date may.
No, you in October some date. Some.
This matter 2 weeks time.
This matter 2
weeks time.
Item 58 for Malad, I could not be here because I was 58 Can be next two more after lunch.
Next. 58.
That's for this is for
11th.
Sir, it is in list.
The list?
Yes, sir.
We have first over.
Yes, sir.
Beg pardon, my lord.
Yes.
Item number 65. The same impute order of the tribunal has been challenged by my adversary by the FO number 468 of 2024. It would be better if my lordship that would be tagged to my case and heard jointly.
Call along with take out that.
FO number 468 by 24. So next week.
Next week may not be in the second week of October, like that. Nice. That second week means second Thursday. Okay. All right. Right.
Item 45.
May I place the matter, my lord? He's not available right.
Well,
Lords, my challenge here is the Lordship will take my appeal under the Odisha Apartment Ownership Act. Has been rejected only on the ground that I did not pay the requisite amount of ₹100, which is the fee which is to be paid while filing the memorandum of appeal.
You did not pay ₹100.
Yes, I had paid short of ₹100. Your Lordship may take an extra 16 page.
That's the only ground.
That is the only ground. Page 113, that is one page order, only ground of rejection of my appeal.
You make good that ₹100.
Yes, my lords. My lords, if this matter can be remanded back, and I'll.
What do you say?
Lords, Mr. Dayanand Mahapatra is appearing for BDA. He's the counsel appearing for competent authority.
Were you pointed out by the registry of the tribe?
No, my lords. But the rule says that I have to pay 100 rupees.
Very well, but when they prepare the checklist.
No. They did not do that. My lords, I have a judgment of the.
It's not a pre-deposit thing like it's a court fee.
Yes, my lords, your lordship.
And it's on quid pro basis.
Yes, my lords.
Although Magna Carta of 1215 said that to none shall he delay, to none shall he deny, to none shall he sell justice. Some court fee will be imposed because on quid pro quo basis, there are two judgments of the apex court. So we'll remand this matter. Let appellant pay 100 rupees. What is that?
That is the only.
Can we deny justice on the ground that court fee paid is deficit and that she wants to make it good now? This is more like Shakespeare's Merchant of Venice, Portia's knife. One drop of blood, not even 1 pound of flesh.
1 pound of flesh.
Not even 1 drop of blood. Yes, check now.
Government.
This is a repetition.
Repetition.
Please be seated. Petitioners appeal case number 2 of 2024. Kindly be seated.
Yes, ma'am.
Filed under section 25(2) of the Odisha Apartment Ownership and Management Act 2023, having been negatived by the tribunal.
My lords, this is the appellate authority under section 25.
By the appellate authority by the order dated 11/2/2025. Come on. Who is the petitioner? Person, body?
No, my lords, they are the flat owners. 6 flat owners have come up before this High Court.
This petition is presented complaining under Article 227 of the Constitution of India, Article 226 having been ornamentally employed in the pleadings. Kindly be seated. First up. Next paragraph. The impugned order being short and accordingly and according to the petitioner bereft of elements of justice, reads as under. But entire order is producing. Next paragraph. Learned counsel for the petitioner argues that her clients were ready and willing to make the deficit good had they been intimated by the registry of the tribunal and the paltry sum of rupees 100 having not been paid because they were not asked to pay, the tribunal is not justified in negating the appeal itself on that ground. First one. Learned AGA, what do you say? ASC, what do you say?
They is the contesting party.
You don't have say anything?
Yes, ma'am.
To make some submission.
I will also not with me, ma'am.
Well, he's also not with you. All right, next paragraph. Having heard learned counsel appearing for the petitioner and the learned ASC, this court is broadly in agreement with the submission of petitioner's counsel that an opportunity ought to have been given to the petitioners to make good the payment of deficit court fee. What do you say? 100 rupees, they are ready and willing to pay. They will pay, and I am remanding the matter to the tribunal. Why the registry of the tribunal did not indicate to them to pay 100 rupees? Nowhere they indicated.
Nowhere.
But one stanza of 1215 Magna Carta reads as under: to none shall we deny, comma, to none shall we delay, and to none shall we sell justice. Full stop. This has been treated by the English courts as a piece of law, and it has great elements which the adjudicatory process should be animated with. First of all, had it been kept in view, the appellate authority would not have negatived the appeal on the ground on which the impugned order is structured. First of all. Next paragraph. It was learned counsel for the petitioners is right in telling the court that the appellate authority is constituted as an exclusive body to treat special grievances, and therefore the principles of natural justice required an opportunity being given to her clients to make good the deficit court fee of rupees 100. First up, there is force in this submission. Even now, she is ready and willing to, the petitioners are ready and willing to make good the deficit court fee. First up. Next one. In the above circumstances, this petition succeeds. Semicolon. A writ of certiorari issues, quashing the impugned order. Semicolon. Matter is remitted to the portals of appellate authority for consideration afresh on the petitioners making good the deficit court fee. Within 8 weeks.
Within, it will be disposed of within 8 weeks, Your Lordship.
Yeah.
Yes.
No.
But the, yes, I'll do that.
All right, full stop. Next paragraph. Parties are put to notice to appear before the through their counsel to appear before the appellate authority. On which date they will appear?
No, it's next week, any date.
Next week only.
No, it's or any date, Your Lordship, because already 1 year since the impugned judgment, any date.
Yeah. On 12th of September 2025 at 11 a.m. and seek orders at its hands. First off, the appellate authority on the receipt of deficit court fee shall hear and dispose of the subject appeal within an outer limit of 8 weeks.
8 weeks.
Okay.
Grateful, my good sir.
All contentions of the parties are kept out.
Grateful.
Okay.
Item 57.
May I please, madam? My friend is here.
Yeah.
Sorry, my sir, I could not approve the matter.
He was in fact on receipt, but the receipt didn't ring.
No, could not connect.
But the short point is the opposite party number 4 has already retired. Your lordship had desired to protect the petitioner shouldn't be further deprived.
Two grievances you said in the morning. One, because I vaguely remember that the submission which the other day you made, the discussion was that he was an outgoing employee. Therefore, he should be permitted to demit the office on attaining the age of superannuation, and which he has done now. So eventually a vacancy has arisen. In that vacancy, he should be.
Yes, I have no objection. But
You are for?
I'm for opposite party number 4.
Or who has demitted the office?
I am
No, you have no say in the matter. You have gone. Yes, who appears for the?
But only thing I want to bring to your lordship's notice that while retiring the senior most lecturer one Jitendra Kumar Das, I have handed over in the charge and I have retired. After that, your lordship, as your lordship, I have nothing to say in this matter. Since one senior most lecturer was available in the college, I have handed over the charge to him.
Which rule said you should hand over charge to a senior?
That is the practice goes on when the one retires, the senior most lecturer is handed over the charge and.
But case was pending here. You were shown concession by the court, although that was not recorded. But you are not denying what discussion took place other day. At least you should have made a memo saying that I am demitting office. To whom I hand over the charge?
Well, because in the meantime, during the pendency of the writ petition, while the writ petition was filed,
who appears for the opposing parties? Who is the answering party?
Answering party is the state.
Yes, brother. What is?
This allotment, madam.
Mr.
Lawrence, AGA, March.
May I bring one? May we kindly look at it?
Unless he is there.
Just one second. If your lordship has a look at it, I think page note 29. There was a direction specifically to the government.
That's what in his absence. Call this matter on. On 9th? And okay. To enable AGA to come and argue. Okay.
Item 58.
Yes.
Last occasion, my lord, directed the state to get the instruction if the postal lying vacant, the seats. In the meantime, I have received through RTI. My lord, may kindly have a glance. For your postal.
That question. What is this?
When they have submitted the instruction, my lord. Let's see, can you glance, my lord, page 1 of my, I may be permitted to place, my lord. Paragraph 3 onwards, my lord, that during the admission process, it was noticed that petitioner is working as accountant cum support staff of block education office Tangi Khurda with consolidated remuneration. Then, my lord, that as the petitioner is an employee working at block education office under the agency of OSEPA, necessary clarification is sought from the OSEPA by letter number such and such in response to the letter of OAVS, that is Odisha Adarsh Vidyalaya Sangathan. OSEPA forwarded the same by letter number such and such dated such and such to government and in school and mass education department for necessary clarification with regard to the nature of service matter. That in response to the letter of the OSEPA, government in school and mass education department by letter number such and such clarified that the employee working under OSEPA cannot be considered as a government employee PSU employee. They are governed under OSEPA, OPEPA.
What is that OSEPA Act? Orissa
State Authority.
Program?
OPEPA.
Odisha secondary education.
Yeah, whether there is such a statute?
Yes, ma'am.
Huh?
And that OPEPA
Is it a statutory body?
Yes,
It's a society. Society, man.
Not a statutory body.
No, man. It's a society where the fundings come from central government as well as the state government, and they have gone into a MOU through which this entire program goes on, my lord. And my lord, can the director say this after my lord has passed Annexure 10 that was passed on 14/8/2025? My lord has taken a decision. Myler had taken a decision in a similar case where Myler had discussed all these things, how they are entitled. Myler may kindly have a glance at page 47. Before that, Myler may kindly I also had asked for one RTI application where I have received this. Myler may kindly have page 39, Myler.
Which page I should see? You are telling me to see 47? I am looking at it.
47, Myler. 47, it's Myler's order. In a exactly similar case. And the objection was same from the learned AGA, and Myler had discussed everything here.
No, that was for an admission of the child.
Yeah, this is same, man.
Yes, so then it is covered by the judgment.
And after that, they dare to pass this order, Myler.
Instruction, Myler. Page 3, Annexure A. Page 3, Lordship Cabinet Class.
Page 3.
That is Myler. That the government has clarified, Myler.
When court has clarified,
Myler.
This is
can
contentious.
government sit in appeal over the court's judgment?
No.
Government was a party there also.
Because you are a party, you are heard in the matter. All your contentions are treated by this judge. I think I have made it reportable judgment also. Because I wanted to put the things clear. No,
Myler.
Not made reportable. Not here for, no?
Not more.
But they're covered by the judgment, all contention, whatever reasoning you have assigned, that runs counter to the reasoning of the court in other similar matter.
And again, Myler, may I draw Myler's attention to page 39? I have received it through RTI from another school, same school.
There is vacancy.
No, Myler. The son of another accountant working on the BO, they have given, they have taken him
On that ground.
They have
The same ground.
Myler.
That is you they have denied.
Myler. Page 39, last one, Myler. Subhasri Barik. Father is an accountant under BO. Hon'Ble, Myler.
Yes, brother, covered by the judgment.
Myler.
Petitioner is knocking at the doors of the court by structuring the prayer as under. First of after service of notice, which are the all workers only.
Myler.
The workers have entered appearance through the learned AC, who make submission in justification of the impugned order that resulted into denial of admission
To class 6th.
to petitioner's ward.
Ward, Myler.
Yes.
Son of the petitioner.
Petitioner's ward to class 6 in Odisha Adarsha Vidyalaya Adipada. Adipada. Tangi.
In the district of
Orda. On the ground that petitioner is not a civil servant nor a government employee, for whom the benefit of 5% reservation of seats does avail. First one. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, comma, the question that arises in this case is no longer a sine qua non, comma, the same having been answered by this court in the case of, which is that, brother?
My lord, page 47, Biren Jena versus State of Orissa.
47.
My lord.
In Biren Jena, that's in WPC number 20108 of 2025 between Biren Jena versus State of Odisha and others, disposed of by this court by the order dated 14/8/2025. Answering the question in favor of the petitioner. First off. Next one. In the above circumstances, this petition succeeds. The writ of certiorari issues quashing the impugned order.
No impugned order.
No impugned order.
No, madam. Here, impugned order passed.
Is there not?
Impugned order, my lord, passed. In my instruction, my lord, page 4.
Dated 21/8/2025.
Yes. So that is their instruction.
Yeah.
Yes. Madam.
That is not part of the records are called and whatever is in bad is amputated.
In complaint to my lord's previous direction.
Stop. One more ground here. One direction. I have covered it, the direction. To police party.
My school is a party.
To the OP schools.
My school is at
to admit petitioner's ward to sixth standard on compliance of usual conditions. Comma, notwithstanding any time bar for such admission and report compliance to the Registrar General of this court. Brother, I impose cost of rupees 10,000 on that officer. Why, when there was order of the High Court, how could he pass such order? That even he has not communicated that order to him.
No, that
it is mentioned only in your note.
That they have sought for instruction since after the order was passed.
Why instruction? There is judgment of the court.
Yes, madam. That is in August, madam. They have sought for instruction also on page 3, madam.
Order was sought for
instruction in 22 April 2025.
From whom?
From government, madam. They have clarified that on 20th August 2020.
Then let government pay the.
Yes, madam. Government that has clarified, madam.
What clarified? Can it clarify the judgment of the
No, madam. Judgment come after, madam.
Subsequent.
They have
no, but as of the date he made the order, this judgment was available.
It's order, madam. We don't have the government's knowledge, madam. 14/8. The order was 14/8.
Subsequently, after seeing this judgment, 14/8/2025 is the order.
Order, madam. And
still there is a tendency to
madam.
trouble the citizens.
And madam, 4 seats are there.
And you have given to others.
No, madam, the marks he has secured, madam, in the next page, madam.
It is not on the ground that he has secured.
They have also provided the instruction, madam. That is my humble submission before, madam.
One more ground here. Learned counsel for the petitioner is right in telling the court that the impugned order, the concerned authority could not have discriminated his client as against others, in as much as children of similarly circumstanced officials have been given admission in other institutions. First of all, this is a fit case for imposition of exemplary costs payable by the concerned official, in as much as the question arising in the case was decided by this court in Biren Jena Supra. First up. However, on the submission of learned DSC, very reluctantly, the costs have been made easy. Then, in the above circumstances, so immediately you have to give admission. When are you going to report tomorrow? Compliance to be tomorrow.
Yeah.
Otherwise, that boy, girl will lose the class. You have to report compliance to the Registrar General of this court within 4 days. Record from this day. First off, what is we act upon? We have copy of this order.
Deep localist.
Fine like that. Okay.
Item 59. My lord, I am the appellant in this case, my lord. And my lord, with your lordship's permission, I would like to file an IA seeking exact copy of the counter affidavit filed by OP number 3.
Why IA? They will give copy only to you.
And report
Copy has already been served.
that is served, but that is not exact copy, my lord.
You take copy from our court record. We'll give you our copy.
May I file this IA?
You are the appellant.
Yes, my lord.
Respondent or appellant? OP or appellant? Appellant has in the open court moved an application supported by affidavit seeking a direction for a true and correct copy of, which is that?
Is counter copy. Counter affidavit filed by OP number 3
Counter affidavit filed by OP number 3
and report of CID, CB, that is
and report
filed
of
state.
That has already been
No, that is not exact copy. That's what I am praying. That's what I have filed. What is exact copy? That is that has been mentioned in this Honorable Supreme Court judgment. I have cited this judgment.
They do not match with each other.
No signed, no true copy signed, nothing else, man. If you let you kindly see. And Honorable Supreme Court has held that what is the exact copy? True version of the court, exact copy is the true copy of the that file in the court. And I am relying on two judgments.
But I am fully agreeing with you that we.
And after that, I shall file.
That is just the nature of your prayer. How it comes to your aid, I don't know.
My lord, actually, on the last occasion only, on 21, this is a transport brief, my lord. And on 21/8/2025, I have entered appearance with my associates. And after going through the records, I found that
It is not the exact copy.
Not exact copy.
What is missing in that? What is the variation?
Well, only that no sign is there, nothing.
Anyway, supply our copy, whatever is.
After that, my lord, I shall file rejoinder in this case.
But this is an appeal under Section 24C of the Orissa Education Act. My lord, the Learned State Education Tribunal has already decided the matter in favor of the respondent number 4, that her appointment is to be approved against the first post of lecturer in English, and she is to get granted aid.
Because he is.
And her appointment has already been approved.
He is a new lawyer in the.
Well, yes, I have no hesitation to supply another copy.
Application also.
We have
I have no hesitation to supply one more copy.
That's what.
But our predicament is the respondent number 4, who is continuing in service and whose appointment has been approved against the first post of lecturer in English. Well, she is not getting granted aid since 2019. She was earlier getting granted aid since her appointment was approved.
And this matter, just
my lord, it's a matter of some months only. It will be disposed of.
No.
I shall find
what I pay.
Only some months.
Lordship, kindly go through the briefs now. If Lordship feels that, Lordship can adjourn the matter. If prima facie Lordship see that what is the wrong in the tribunal order, Lordship, these These are the statutory proceedings.
That depends upon the
Statutory
Yes,
procedure.
obviously, but your lordship will.
She has to argue.
No, it will take time, and I am deprived of getting my salary. There is usually one lecturer is not. He is a terminated employee. Your lordship can modify the system.
His services were-
I should get the current salary. Then your lordship modify the order.
Well, his services were terminated since 2008.
Why for about 3 days, 4 days, why you are all making so much kata? Any issue?
3 days. I have been mentioning this matter
And,
last 1 month.
I'm fixing the date.
No, you should directed. Yes, this is a good day for me because my matter is this. Because this is a very difficult matter. What I pray lordships to list matter in the heading orders. You should directed.
Correct.
These are specific directed.
It is posted.
Visual as a main predicament, specific directed to list matter in orders. However, it does not come. So 107, that application since 2022 is there. My specific prayer will let the current salary be released. Lordship can hear the matters.
Yes.
No hesitations.
Because he is continuing in service
Getting also.
and he is out of employment.
Right. Nothing is that. Call this matter on. No, what is that? Whether are you giving the copies or we have to make the direction?
No.
Give copies.
Yes,
Well, I will serve.
Yeah,
I have served the copy of my.
what you are written on the application? Yeah, you give your copy. This one, the first one. Next paragraph. No order needs to be, no positive direction need be issued in terms of the application in as much as learned counsel representing.
I am respondent number 3. I am respondent number 3.
3.
I am 4.
And ASC
Number 1 and 2.
representing the OP numbers 1 and 2 have graciously agreed to supply the true and correct copy of an exam.
Counter affidavit.
And
The report of CID.
report of
CID.
so and so, so and so. Two learned counsel representing the appellate forthwith.
Yes.
Yes, forthwith. First. Petitioner, the appellant is granted leave to file. What you want to file now?
Rejoinder ballot.
Rejoinder.
But this is a statutory
3
procedure.
weeks. They have filed counter. I need to reflect.
Rejoinder. After serving a copy thereof on all the learned advocates appearing for the parties. First up, call this matter on 9/9/2025 in the orders list.
Yes.
I place some more this. I place some more.
How many days? You're 19th or 16th?
On 16th.
On 16th.
Yes, yes.
16th also. Finally, 16th. This date is chosen.
Yes.
That counsel appearing for the appellant from the calendar. Okay.
Normally,
Deeply obliged.
normally it's to Thursday matter. Info matters are normally posted
Then
on the
Thursday.
Thursday.
Right. We will put it on the Thursday.
That is 18.
18.
Okay.
What are orders?
Orders. The orders.
Deeply obliged.
So why salary not being paid? Mr. Prasad, just look into that. Why that is not being paid? And
State is to look into that.
preventing the payment of salary.
The state is to look into that.
2019, I am not getting.
Why?
State is to pay.
But for the first post of a lecturer, well, there is controversy and appointment, forgery appointment, all these things are there.
But there is an order by the tribunal.
Yes. And crime branch inquiry is also there. That is also in favor of us.
All right.
Deeply obliged, man. Deeply obliged.